This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hi everyone, I'm Leonard French, your favorite copyright attorney, and we have quite a show for you today, including an improvised introduction. If you can see, I have made it successfully to Luxembourg, so expect a video on that in the near future about how I successfully traveled with my wife back there. Well, not with her, but to her, I guess. I'm really excited if you can't tell. It is warm here. It's warmer than I'm used to. We don't have air conditioning, and Luxembourg is traditionally a little bit cool, so I might need to turn a fan on in the background if you start seeing me profusely sweating here. But yeah, how are we doing? Okay, this is a brand new setup. Before we get started, is the audio in sync? Are we having any issues that I might be able to take care of before we get started? All right, you guys tell me in the chat, and I will tell you what's going on with today's story. So as you know, Richard Liebowitz is one of the world's most prolific attorneys that we call a copyright troll. Normally we call a plaintiff a copyright troll for being an aggressive plaintiff. One plaintiff, like Malibu Media or Strike 3 Holdings, might file thousands of lawsuits and do it in a very copyright trolling manner. Prenda Law filed a whole bunch of lawsuits that they claimed were for other plaintiffs, but it was actually only on their behalf. And there's news in that story. They want to restart that whole scheme, but they want to do it right. So we're going to go over that at another live stream, probably tomorrow. With Liebowitz, Liebowitz has more or less made a name for himself. He's advertised, he has gone to conferences, he's spoken, he's given educational talks about how to protect your copyrights as a photographer. This is good. We want attorneys to reach out to potential plaintiffs and help them enforce their rights. We want people to enforce their rights through the legal system as opposed to extrajudicially or not at all. If the right is worth pursuing, is worth fighting for, then yeah, we want people to have the ability to pursue it. And if they can't pursue it, because maybe there aren't enough Richard Liebowitzes in the world, we call that an access to justice issue. So I'm not upset with Richard Liebowitz in any way for wanting to be a plaintiff's attorney or wanting to be an aggressive plaintiff's attorney. What I'm upset with him for is this kind of thing, what we're about to see here, where he makes not just a normal human level of mistake, but he's made so many mistakes, and so many of them seem to be unnecessary mistakes. They seem to be not because a person just naturally makes a few mistakes, but rather because a person has overloaded themselves, and that one mistake has then been doubled down on. We keep the overloading, we keep the large number of cases, we keep the burden on ourselves, and then we can't file cases without making a lot of mistakes. Well, he's made some mistakes in the Arthur Usherson versus Bandshell Artist Management case. And he recently got a 54-page opinion and order that Judge Jesse Furman wrote to him and ordered him to do many things, some of which were writing to other courts and telling them about Judge Furman's sanctions. Richard Liebowitz wants to appeal that. Richard Liebowitz does not like that Judge Furman has ordered him to do this. It's probably going to make a few of his clients aware of things they might not have been aware of. I don't know, but there's some accusations in here that he isn't telling his clients everything. So if it's true that he isn't telling his clients everything, then sending an order explaining what's been going on from the judge to the clients and other courts and judges and things, well, that might just shine a giant flashlight on something Richard Liebowitz does not want a giant flashlight shown on. So he wants a stay. He wants to appeal, and he wants this judge, Jesse Furman at the district court, to put his sanctions on hold while he appeals his case. And so here is the judge's opinion. This is not Richard Liebowitz's words. This is the judge's opinion denying his request for a stay. And before we get started, I want to take a look at this first sentence. It says, on June 26th, the court issued a 54-page opinion and order. June 26th was how long ago? Well, June had 30 days, and so it would be 30 days between June 26th and July 26th. And this was issued on July 22nd, so it's like 24 days after the June 26th order. And so keep that in mind. And Judge Jesse Furman writes, on June 26, 2020, the court issued a 54-page opinion and order, familiarity with which is assumed. We made a video about it. You can go watch that. It was one of our recent Liebowitz videos. We have a whole playlist for Liebowitz, and you should be able to find it pretty quick. It's Usherson v. Bandshell Artist Management, but I forget what we called it. You'll find it a couple videos ago. The sanctions imposed a range of monetary and non-monetary sanctions on the oft-sanctioned plaintiff's counsel, Richard Liebowitz, and his firm, the Liebowitz Law Firm. The sanctions were based on 3 sets of detailed findings. First, that Mr. Liebowitz had violated at least 6 of the court's orders. Second, that he repeatedly lied to the court, including under oath at a hearing, about whether he had been granted permission by the mediator for his client to participate in a mediation session by telephone. And third, that he had failed to reasonably investigate whether the photograph at issue had been registered with the Copyright Office. Spoiler alert, it hadn't. Both prior to filing suit and when put on notice about the issue during the litigation. The court found that the sanctions, several of which involve notifying other clients and courts about the court's opinion and order, were reasonably necessary to deter repetition of the misconduct given Mr. Leibowitz's long and ignominious history. Mr. Liebowitz and his firm had 30 days to comply with several of the sanctions. 2 evenings ago, that is, 24 days after the court's decision, and only 4 business days before the deadline, they filed a motion styled as an order to show cause, asking the court to stay those sanctions pending appeal. In deciding whether to issue a stay pending appeal, the court must consider 4 factors. 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4, where is the public interest in all of this? The first 2 factors, the likelihood of success and irreparable harm, are the most critical and have typically been evaluated on a sliding scale, so that a strong showing that the applicant is likely to succeed excuses a weaker showing of irreparable injury. Nevertheless, as the Supreme Court has emphasized, the applicant must demonstrate that both factors are satisfied, so that even if a party makes a robust showing that it is likely to succeed on appeal, it must also show that irreparable injury is likely. A stay, moreover, is not a matter of right, even if irreparable injury might otherwise result. It is instead an exercise of judicial discretion, and the propriety of its issue is dependent on the circumstances of the particular case. Ultimately, the party or parties seeking the stay, here Liebowitz and his firm together, bear the heavy burden of demonstrating that a stay is warranted. Applying these standards, the court finds that the movants do not come close to carrying their heavy burden. The court is tempted to leave things there and let its opinion and order, with its exhaustive findings and analysis, speak for itself. Mr. Leibowitz's shenanigans have surely consumed enough of this court's time and resources as it is. But a few observations are in order, if only to aid the circuit, in the event that the movants decide to now burden that court with having to decide on short notice whether a stay pending appeal is warranted. How do you know that a judge doesn't like you? It's this. You know the judge doesn't like you. Irreparable harm. For starters, the movants' claims of irreparable harm ring hollow for several reasons. First, the movants' principal claim is that the sanctions, which require service of the court's opinion and order on both current and future clients, and in current and future actions, will result in severe and irreparable reputational and economic harm to their law practice. I mean, what do you think the consequences of your actions are? Or should I say, well, if it isn't the consequences of my own actions? Liebowitz. But any harm to movants' reputations resulting from the mere act of sharing the court's opinion and order is not caused by the sanctions themselves, but by growing awareness of Mr. Leibowitz's own conduct and record, which are accurately recounted in the court's opinion and order. Notably, the movants attack none of the history recounted in the court's opinion and order, and few of the court's factual findings, and as discussed below, their attacks on those findings are entirely unpersuasive. Significantly, the court did not bar or even inhibit the movants from filing any new action, though such sanctions have long been approved with respect to vexatious litigants. Courts have recognized that the normal opportunity to initiate lawsuits may be limited once a litigant has demonstrated a clear pattern of abusing the litigation process. Instead, this court's order, its order merely requires the movants to share information, that is, the opinion and order, with their clients and any courts in which they appear for a time, on the theory that they may be deterred from further misconduct by the knowledge that their clients and courts are likely to be more vigilant. And the judge writes a footnote. Notably, the court's opinion and order does not preclude Mr. Liebowitz from doing so in a manner that notes his disagreement with the court's findings and sanctions, or the fact that he plans to challenge them on appeal. So the court's saying he could include something with the court's opinion and order. In other words, you don't just get an empty envelope with only the court's opinion and order coming from Richard Liebowitz with no explanation. He can write, attached is the court's opinion and order. I disagree with this opinion. I'm appealing this opinion. I think I did this, this, and this, and I really helped my clients out. He could have turned it into something. It might not have overcome everybody's, disagreement with Liebowitz, but it would have been a chance. So, requiring a party to share truthful information, says the court. Here, that is, this court made certain findings and, on the basis of those findings, imposed sanctions on the movants. It does not constitute irreparable harm. Our system does not treat dissemination of truthful information in furtherance of a legitimate governmental objective as punishment. Public records, by their very nature, are of interest to those concerned with the administration of government. Second, to the extent that awareness of the court's opinion and order will cause the movant's reputational and economic harm, much of that harm has already occurred. As the old saying goes, the cat is out of the bag. The court's opinion and order is a public document, and due in no small part to Mr. Leibowitz's well-deserved notoriety, it has already received fairly extensive publicity in the press and social media, particularly in the copyright world. Oh, I kind of feel like the judge is talking about me. I know, they're talking about Law 360 and the big players. Still, granting a stay would not undo any of that damage, which, needless to say, is ultimately attributable to Mr. Leibowitz's own deplorable conduct, rather than to the court's opinion and order itself. Put another way, the potential harm here is not irreparable, it is only marginal. See the Dexter v. Cuomo case in 2011 from the Second Circuit Court of Appeals, finding no irreparable harm based on the reputational damage from a legislative declaration where the legislation was already enacted. See Star Boxing v. Tarver from the District Court, rejecting irreparable harm to reputation where embarrassing fact was already known in that case, boxing circles, so whatever embarrassment could arise had already occurred. And Alvarez v. City of New York, a 1998 District Court case, rejecting irreparable harm to reputation where the fact of investigation was already publicized, so any damage was already done. Finally, a court must consider a plaintiff's delay in seeking relief when analyzing whether the plaintiff will suffer irreparable harm in the absence of relief. That is because inexcusable delay in filing a motion to stay severely undermines the argument that absent a stay, irreparable harm would result. See Hirschfield versus Board of Elections, a Second Circuit 93 case rebuking the Board of Elections for seeking a stay 28 days after judgment was entered and only 6 days before Election Day. As noted, the court gave the movants 30 days in which to comply with the relevant sanctions or seek appropriate relief. Nevertheless, they waited until day 24 to seek a stay, at which point, no less, they proposed giving their adversary only 3 days to respond. Simply put, the movants' delay in itself belies their conclusory assertions of irreparable harm and is enough to defeat their claims. Yeah, that sounds pretty good to me. So they waited 26 days and now they want to stay. They still have time to comply with the court's order. They still have time to move for a stay, but they don't really have time to let the opposing side respond to a request for a stay, and they don't have time to wait for the appeals court to rule on a stay, so they have to do it now. And that's not right. If he felt that he had grounds 24 days ago or 26 days ago, he should have filed something much earlier than 26 days ago. Remember, he's not saying I need more time simply to comply with the court's order. Maybe if he said, I have 4 days to go and I don't have enough time, I'm not going to make it, yeah, that's when you ask for more time to comply with the court's order. He's asking for more time to disagree with the court's order, and he hasn't put together his disagreement but 2 days ago. Likelihood of success on the merits. At best, the movements make only a weak showing that they would suffer harm in the absence of a stay. It follows that they need to make a correspondingly strong showing of likelihood on the merits. In particular, that requires them to do more than raise serious questions about the court's opinion and order. Yet, conspicuously, they do not even attempt to do so. Indeed, their boilerplate recitation of the standard aside, the movement's brief does not even include the words likelihood or success. In any event, they do not even meet the more flexible serious questions standard. The first attack on this court's factual findings about Mr. Leibowitz's lies with respect to the mediator and his knowledge about the photograph in question was not registered prior to filing the complaint. But, reading their motion papers, one wonders if they even read the court's opinion and order. With respect to Mr. Leibowitz's lies regarding the mediator, the movements do little more than cherry-pick a single email that they argue, unpersuasively, is more equivocal than the court acknowledged. In doing so, however, they all but ignore the fact that the court's findings were based in large part on its credibility assessments, following a full-blown evidentiary hearing of the mediators and Mr. Leibowitz's testimony. So when a court holds a factual hearing to find facts, they take testimony. That testimony becomes... It's not like an established fact, but rather it's something you testified to under oath. So that has a certain amount of weight to it automatically. And then how you testify, how you carry yourself, how you answer the questions, both the things you don't say, the things that you do, your attitude, your demeanor, the whole you're carrying yourself, those all go towards credibility determination. Now, credibility is a very, very soft concept. This is not, a score on a score sheet. It's a human weighing of how much do I believe you or not believe you, like L.A. Noire, press X to doubt, that kind of thing. So, if you think about it hypothetically, you can get all complicated. Well, how would the judge ever know how to Mr. Leibowitz's credibility and this and that? No, you just do it as a human being. You listen to Mr. Leibowitz's testimony. You watch and listen to the mediator's testimony. One of them will make more sense. One of them will have more credibility than the other, especially if there's a factual disagreement. If one person is saying something happened, one of them is going to be lying. But even if it's not a situation where it's, if it is a situation where it's open to interpretation, you can still easily make a credibility determination based upon what the people do and say. And so that's what the judge is saying here. He evaluated Mr. Leibowitz throughout the entire thing, of course, and he finds him to not be a credible witness. And he's a witness against himself, of course. So the judge is taking into account Leibowitz's bias because he's defending himself. You're gonna try to defend yourself with a bias towards yourself, of course. But even given that, still finds that Mr. Leibowitz's testimony is incredible. So incredible that he is discreditable. Let's see, he gives a couple examples. An example explicitly crediting the mediator's testimony based on both observations of the mediator's demeanor and the corroborating evidence. Another time, finding Mr. Leibowitz's testimony unworthy of belief, patently incredible, on its face incredible, based on his demeanor at the hearing and the content of his testimony. And there's a footnote. The movements assert that the court discounted some portions of the mediator's testimony, and note the court's ultimate conclusion that one subject of the hearing, whether the mediator gave Mr. Leibowitz advance permission to send an associate in place, was too muddled to make factual findings as to Mr. Leibowitz's bad faith by clear and convincing evidence. If anything, the court notes, those features of the court's opinion and order show the care that the court took in making its findings and ensuring that it imposed sanctions only to the extent that the evidence clearly and convincingly supported those findings. In any event, it is well established that a fact finder, here the judge, is not required to treat credibility as an all or nothing matter, but may credit portions of a witness's testimony and discredit others. In light of the particularly strong evidence owed to the court's findings in such circumstances, the movement's arguments do not come close to raising questions, let alone serious questions, about the court's decision. Meanwhile, the movements attack a straw man when they contend that the court erred by finding that Mr. Liebowitz initiated this action knowing the photograph was unregistered. Put simply, that portion of the court's sanctions decision was not based on a finding that Mr. Liebowitz knew when the complaint was filed that the photograph had not been registered. Indeed, the court acknowledged that Mr. Liebowitz may not have personally known about the lack of registration at the time of filing. Instead, the court faulted Mr. Liebowitz and his firm for their inexcusable failure to conduct a reasonable investigation before and during the case. Moreover, the movements conspicuously focus solely on Mr. Leibowitz's knowledge when the complaint was filed and say next to nothing about the court's findings and analysis with respect to his or the firm's knowledge and conduct during the case. As the court emphasized, however, whatever knowledge the movements may have had before filing suit, they certainly knew or should have known about the untimely registration by November of 2019, when defense counsel explicitly put them on notice that whatever turns out to have been a fatal defect, or put them on notice of what turns out to be a fatal defect in the complaint. At that point, if not before, the movements had an obligation to investigate, yet they conducted no investigation whatsoever until ordered to do so months later by the court. To the contrary, Mr. Liebowitz affirmatively presented to the court that the registration alleged in the complaint was the correct one, and resisted discovery on the issue. Mr. Liebowitz did not admit, as the movements do now, that he lacked independent knowledge of the registration, let alone acknowledge, as the movements do now, that the allegation in the complaint was false. Had he done so, the court and defendant would have learned sooner that the case was fatally flawed from its inception. Next, the movements contend that the scope and severity of the sanctions are disproportionate to the misconduct. The court is confident, however, that the record set forth in the opinion and order taken as a whole justifies the scope and severity of the chosen sanctions. In a footnote, the movement suggests that the court may have separately erred in sanctioning Mr. Liebowitz and his firm for their conduct before other courts. Putting aside the fact that a party may not raise an argument in a footnote, that argument is frivolous. The court did not rely on the movement's violations of orders in other litigation as the basis of its decisions to impose sanctions. So, in case any of you were wondering, why doesn't one of these courts just shut it all down? Because the court doesn't have the power to shut other things down, just the things before the court. And each court, by the way, is a different judge, and that's the cutoff. So, different judge, different jurisdiction. Instead, it took stock of Mr. Leibowitz's long and ignominious history in evaluating what sanctions were necessary to deter further misconduct. The court is not aware of, and the movements do not cite, any authority for the extreme proposition that a court should blind itself to an attorney's history of misconduct in crafting appropriate sanctions. Ironically, the cases that the movements themselves cite make plain that the court acted well within its authority in imposing the sanctions on a nationwide basis. In Gallup v. Cheney, they required counsel to provide notice of sanctions imposed upon him in the case to any federal court in the circuit before which he appears or seeks to appear for a period of 1 year from the entry of the order. Enman v. Prospect Capital Group, affirming the district court's sanctions order, requiring a firm's lawyers to submit the order with any pro hoc vice applications in the Southern District of New York. Indeed, if anything, the movement's own cases suggest that the court did not go as far as it could have, given that the sanctions are limited in time and do not limit their ability to file new cases, but merely require disclosure. The movements are undoubtedly correct in asserting that nationwide sanctions are rare, but that is only because they are rarely warranted. Here they were, as the record makes clear that the movement's practice and misconduct has begun to spread to other districts. The movements may have expanded the geographic scope of their practice in order to file more cases and make more money, or they may have done so in an effort to escape Mr. Liebowitz's well-earned reputation as a problem in this district. Not surprisingly, his reputation seems to have either preceded him or to be catching up with him. Note that Mr. Liebowitz's unprofessional and blameworthy conduct is consistent with the extensive public record of discipline he has amassed in courts across the United States. Mr. Leibowitz's continued practice of law represents a clear and present danger to the fair and efficient administration of justice. Oh, so that one's from Colorado. The previous one was from Northern District, California. And either way, the decision to expand the firm's practice is a strange one, given Mr. Leibowitz's own acknowledgement that his business management practices are not the best and that things need to change. Given that record, limiting sanctions to this district or this circuit would not have been adequate to deter repetition of the misconduct. The movements could simply file suits elsewhere. That is, the court's sanctions ensure that, for at least a year, any courts in which the movements are litigating are alert to Mr. Leibowitz's past activities so that they may take judicial notice of matters relevant to new litigation brought by him. Anything less would be insufficient to deter repetition of Mr. Leibowitz's misconduct. Finally, the movements assert in passing that by requiring the movements to file a deposit copy of the copyright registration upon the initiation of this action, the court impermissibly altered the statutory presumption of validity in copyright cases. Not so. The statute at issue provides only that possession of a registration certificate creates a rebuttable presumption that the work in question, that is, the work covered by the certificate, is copyrightable. The presumption, however, is not even remotely implicated by the court's sanction, requiring the movements to verify and confirm that any work at issue in a new lawsuit is actually registered, which, after all, is a statutory condition precedent to even filing a copyright claim. Condition precedent is just like a condition that you have to fulfill before, as opposed to a condition that comes after, or a condition antecedent. Moreover, the movement's argument, there's a footnote. The statutory presumption recognizes that the Copyright Office has expertise to determine in the first instance whether a filer has complied with the technical requirements for a copyright registration certificate. Needless to say, the court does not undermine the Copyright Office's expertise by requiring the movements to confirm that the Copyright Office did in fact review a work and issue a certificate. Moreover, the movement's argument falls flat for another reason. This sanction was imposed on them. The sanction was imposed on them based on their history of failing to investigate the evidentiary basis of their own pleadings, not on their current or future clients. That is, although violation of the sanction would subject the movements to contempt of this court, it would not in any way, at least absent independent action by the court presiding over the new action, affect the substantive rights of the movement's clients themselves. On a related note, the movements complain that the costs and delays involved in obtaining deposit copies of the registered works will reduce their clients' recoveries and may result in a statute of limitations problem. Skipping the rest of that, the court does actually agree, and the court gives them a special order just to deal with that sort of limbo period where they need to get the deposit copy and they can't get it fast enough to file the copyright suit. If they need to file the copyright suit fast enough, the judge gives them a way to do that. Public interest. The final relevant factor is whether the public interest favors or disfavors a stay. The court agrees with the movements that a stay would not cause substantial injury to the other parties interested in this proceeding, as the sanctions do not directly benefit the defendant. The harm to other litigants and the interests of justice that may result from delaying the sanctions is a factor in the public interest analysis. So the judge acknowledges that they're going to take that into account. In the court's view, there is a strong public interest in shining a bright light on Mr. Leibowitz's extraordinary record of misconduct, and in ensuring that both courts and his clients, current and future, are aware of that history so that they might be vigilant in scrutinizing Mr. Leibowitz's conduct. Sunlight is said to be the best of disinfectants, electric light the most efficient policeman. Noting, in reference to the thing, knowledge of the proceeding is subject to contemporaneous review in the public forum, or in the form of public opinion, is an effective restraint on the possible abuses of power, and that the presence of interested spectators may keep participants keenly alive to a sense of their responsibility and to the importance of their functions. I say embrace it. Liebowitz should have his own YouTube channel where he competes with us to be your favorite copyright attorney. I think that would be great. Against that strong public interest, the movements cite the interest in the continuation of their law practice because they have carved out a successful law practice that provides a realistic prospect of recovery to copyright plaintiffs in relatively low-dollar infringement cases that otherwise go unfiled. But the sanctions do not bar movements from continuing their law practice, and movements' conclusory assertion that such cases would not be filed without them is unsubstantiated. Moreover, to the extent that the movement's success is built on unsavory business practices or conduct unbecoming an officer of the court, it is, of course, not at all in the public interest for it to be perpetuated. Nor do the court's sanctions deprive photographers of the opportunity to hire Mr. Liebowitz or his firm to bring suit. The sanctions merely ensure that such photographers do so with their eyes wide open, cognizant of the fact that they could be left holding the bag on a hefty attorney's fee or sanctions award, and of Mr. Leibowitz's tendency to cut and run, perhaps sacrificing their interests in the process when he feels that the heat is on him personally. And in short, or I guess that was the end of the sentence. In short, insofar as the sanctions provide Mr. Leibowitz's clients and court with more information about his past, it is in the public interest for them to go into effect now while the grievance committee ponders Mr. Leibowitz's fate longer term. We'll get to the conclusion in a moment, but I have kind of a juicy detail. We've had contact from a number of anonymous sources who have said that they were involved in a Liebowitz case at one time, and they have been contacted by the grievance committee. So I have no further details that I can offer, but it has begun. I can confirm, according to several anonymous sources, the grievance committee is doing their job. Also, let's thank the super chats before I get too much further. Thank you very much to Zach C. Luxembourg. Congrats to you both. I really appreciate it. And innocuous remark, thank you for the $10. Greeting from humid Bucks County, PA, and from Hot Grills in Your Area. So glad to see you were finally able to see your beloved. Thank you so much. All right. In sum, the movement's 11th hour request for a stay of the court's sanctions pending appeal is denied, and the court's sanctions remain in full force and effect with the following modification. In any case in which the movements have a good faith belief that waiting for the deposit copies might cause their client's claim to be barred by the statute of limitations, they may file, instead of the deposit copies, an affidavit informing the court of that belief, confirming that they have applied for the deposit copies and are awaiting their delivery, and representing that they will promptly file such copies promptly upon their receipt. Very promptly, because they put it twice there. Nor will the court grant the movement's alternative request for an administrative stay pending the circuit's decision, the appeals court, on whether to grant a stay pending appeal. Granting an administrative stay would obviously ease the burden on the circuit in the event that it is called up to decide if a longer stay is warranted, but in the court's view, that virtue is outweighed by the vice of rewarding an applicant or appellant for dilatory conduct. Deadlines matter, and having given Mr. Liebowitz and his firm sufficient time to comply or to seek a stay, the court should not be forced to alter its deadline merely because they waited until the last minute to do the latter. Instead, in the event of an appeal from this order, the court will leave it to Mr. Liebowitz and his firm to explain to the appeals court circuit why they put that court in the position of deciding whether to grant a stay with only a few days remaining on the clock. So ordered July 22nd, 2020, New York, New York, Judge Jesse M. Furman, United States District Judge. So yeah, Liebowitz is feeling the heat, I think. In fact, while we're live, let me just do a quick search and just see if there are any more Liebowitz law firm cases. Because he hadn't filed any since June, last time we checked. So, give me 1 second here. Liebowitz law firm, new cases. Nope, I was wrong. July 21st, there is a new Northern Texas copyright case with Liebowitz and Shepard Mullen. So, yeah, Southwest Airlines, Giles versus Southwest Airlines Company, 3:20 CV 01919. And Southwest Airlines are represented by Shepard Mullen, and the plaintiff Thomas Giles is represented by Richard Liebowitz. So yeah, that's not the last Liebowitz case. So what do you guys think? He should be shut down sooner than later, right? I imagine if some other attorney got disciplined and then they were like, but hey, wait a second, like my punishment is harsher than what Liebowitz has been suffering. He's lied to the court and everything, and he hasn't gotten disbarred. He hasn't gotten suspended. But it doesn't work that way. The disciplinary committee will take a long time. It will take a year or two. Heck, the disciplinary committee could have been on this already before all of this and just still hasn't finished their decision yet. It takes them sometimes a couple years, and then they will bring the hammer down. And it's Thor's hammer. I mean, it's just gonna flatten everything. It does a lot of damage. It's not a kid's toy. So Liebowitz is going to face that, and it's just a matter of time. And sometimes maybe the thing to do when you're in that situation is make one giant push before you're wiped out. Or maybe what he should really do is eat crow while the crow is young and tender and comply with the court's orders and change his misbehaviors, make progress, become a better practitioner, and then this will all be way behind him. And everyone will recognize that he recovered from this and became a better attorney. So it's good things would happen if he did it. But can he do it? I don't know. And we'll see what happens. So that is our show. I'm going to do my outro now. But if you have any last thoughts you'd like to get into the chat, go ahead. I'm looking now. I know I often don't, or I'm often not able to look at the chat while we're doing the whole reading of the case and everything. Maybe I should take more time to do that. But these things run long, We're already at 40 minutes. So I feel like this crow is 3 weeks dead and full of maggots. Yeah. You better eat the crow while it's young and tender, or apparently you'll eat it when it's old and disgusting. And it's no one crow, it's a whole flock of crows at this point. And yes, Shepard Mullen isn't a small firm. They will flood this guy with motions and discovery. They know what to do. They know how to handle him. And here's the thing, though. He could still file a meritorious case. Remember the good mythical morning case that we always refer to with the Norwegian prison photo? That was a good case. Like, whether or not, it was just a single case over a single photo, and who does that? But, okay, if there was a violation, you want to assert your rights. And we believe that that was a very instructive case because the photo of the prison was used to illustrate an article about the prison. That's exactly the kind of thing that you're supposed to pay a licensing fee for. And remember, the example we gave was that if the photo had been used to talk about, say, what kind of trees grow in the area or something, that's probably closer to a fair use because the photo wasn't for the purpose of describing the trees. The photo was for the purpose of showing the prison. So different purpose means possible transformation, which is much closer to fair use, if not already over the line. So Liebowitz does file good copyright cases. It's just the way he conducts himself in the copyright cases that we're concerned about. So that's our show. Oh, and we've got 2 kitties up on the cat tree back there for you. See if I can turn one of my lights so you can get a little better view of the kitties. There you go. Got a little more light on the kitties for you. So that's our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite YouTube, Floatplane, and Twitch legal education and news channel. We are community supported, meaning we need your cash money to keep this thing going. I want it to grow. We're going to make this bigger. We're going to make this into a full legal education production. We're going to do CLEs. We're going to interview other lawyers. We're going to turn it nonprofit. It is not nonprofit yet. Maybe by the end of the year. We'll see. I just got here to Luxembourg. I got a lot to think about. New beginnings. So, but we need your money. So thank you to the following supporters in the month of July. Special thanks to BU1 Simmons for your support. Really appreciate you there. Thank you to the following $50 plus supporters. Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, by the way, they're coming back, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandon Abel. The $5 plus supporters will be in the description below as soon as I get done with the stream here. And I will put all of you in the crawls of the VOD videos, the videos on demand that drop. I could probably do a crawl for these things, couldn't I? I think the Black Magic and the thing do an alpha channel, so I could do that. And OBS observes alpha channels, so we'll see. We'll work on it. Anyway, our next two videos are going to be really great. So Liebowitz in the Glenn Craig thing had that hearing, and Glenn Craig was not credible. Very politely, let's just say his testimony was not credible, and so Liebowitz really was the victim there, or really is the victim there, and so we're going to go over that. We did a bit of a transcript of the hearing that we attended, and I will go over, we might even do dramatic readings of the most dramatic sections of that hearing. And Prenda Law is back at it. Paul Hansmeier is literally trying to restart the Prenda Law copyright trolling scheme, the honeypot scheme. He wants to restart it from jail. So we're going to figure out what in the world he's asking for. He hand wrote a complaint for a declaratory judgment that he could start his copyright trolling scheme. So he wants the court's permission. He wants the court to say it's okay for him to copyright troll using a honeypot scheme, which is a little bit different than at least we know Mallow Media and Strike 3 are doing. If they're doing a honeypot, that's fine, but we don't know that. If they're doing a honeypot, we would definitely be doing something about that because courts should know. The argument is that a honeypot is an implied license, is that if I put it on the internet for you to download, I can't catch you downloading it illegally because I put it there. If you put it on the internet, okay, you're guilty of something. But if I put it on the internet, I put it there for you to download. So if these guys are going to honeypot, which means seeding torrents to Pirate Bay, that's an implied license. So that's not going to work. But of course, they're counting on defendants settling their cases. And then they'll cut and run anytime that somebody challenges the honeypot scheme. I predict that's what's going to happen. Anyway, we will go over that tomorrow in probably another live stream. At some point, I'll get back to making regular videos, but I'm super happy and stoked to be here. Anyway, love you. Have a good one. Bye. I don't have a way to black my screen. I forgot to put a black screen in here. There we go.